Hi John, we see you now.
ได้ยินหรือเปล่า
Okay.
John, can you hear me? Okay. Can
Yes,
you
I can hear you
speak?
just fine.
Okay. รู้สึกว่ายังเบาไปนิดนึงอะค่ะพี่ ฝั่งเขารู้สึกว่าเบาไปนิดนึง อันนี้ต้องให้เขา turn on volume หรือเปล่าคะอ๋อ
ได้ขอบคุณครับ
ฮัลโหล
ให้เทสอีกทีไหม เริ่มได้เลยใช่ไหมคะ เริ่มได้เลยโอเค Good evening, everybody. Thank you so much for coming to the FCCT tonight. I know that it's Friday night and you can be anywhere. Thank you for choosing to be here. My name is Ploy Chanprasert. I'm the director of DigitalReach, who is directly involved in the investigation regarding the abuse of Pegasus in Thailand. And I'm going to be a moderator for tonight's event. This event is about the case of Jatupat Boonpattararaksa, sitting on the far right, who is also as Pai Dowdin, who filed a lawsuit against the NSO group on July 13 last year. You may have already seen him in the media if you follow Thai media. He's here with us. I want to talk about NSO group a little bit, just for those who are not familiar with the case. NSO group is an Israeli surveillance firm who developed a spyware called Pegasus that has ability to infiltrate mobile devices in order to track movement of devices owner, learn about their private information that is kept in their devices, and it can access photo, messages, or just how the person is using their phones. Next to Pai is his lawyer, who represent him in the court, Chatmani Traisonthi, and next to me is Yingshi Pachanon, who's a key person in the investigation and key person in the court as well. He's an iLaw manager and also DigitalReach board member. The case followed the investigation between iLaw, DigitalReach, and our online speaker, John Scott Relton, who's a senior researcher from the Citizen Lab. He's here with us today as well.
Hello, everyone.
This case follows the investigation between iLaw, DigitalReach, and the Citizen Lab on the abuse of spyware Pegasus in Thailand in the height of pro-democracy protests in the country. From 2020 to 2021, we found that at least 35 individuals were infected with Pegasus spyware, and Pai is one of them. The witness hearing happened on September 3 to 6 and 10 of 2024. Unfortunately, in the yesterday court ruling, the case got dismissed. That means we lost. We are going to go into details about this later, but before we did, let me talk about how we work together a little bit between iLaw, DigitalReach, and the Citizen Lab in order to provide you some background, as it's really important before we move to the highlight. So in late 2021, some activists in Thailand received a threat notification from Apple suggesting that their phone might be targeted by state-sponsored attacker. I talked to Yingshi as he also received the threat notification from Apple, and I contact our partner organization, the Citizen Lab at the University of Toronto, to check Yingxi's phone, and that's how we have learned of Pegasus present in Thailand for the first time. Later, Yingxi, together with his team at iLaw, reached out to activists in Thailand. I checked their phone using the technology of the Citizen Lab for those whose devices are found to be positive. We then send a copy of the devices file to Citizen Lab for digital forensic analysis. That's how we work together, briefly. Let's get into the detail then. I will start with Pai. Why did you... He's gonna talk in Thai, and I will translate. Why did you decide to file the lawsuit against the NSO ทำไมถึงตัดสินใจฟ้องคะ
ครับก็โดนละเมิดสิทธิ์ครับก็คิดว่าเราก็อยู่เฉยๆไม่ได้ครับเราจะตอบโต้อะไรได้บ้างก็ร่วมมือนะครับก็คือให้ความร่วมมือกับiLawนะครับในการที่จะตรวจสอบข้อมูลจนไปถึงการเป็นตัวแทนในการฟ้องคดีครับผมรู้สึกว่าเรื่องนี้มันสำคัญมากครับการที่มีใครคนหนึ่งเข้ามาเจาะความเป็นส่วนตัวของเราครับในยุคสมัยที่โอเคครับลืมครับ
So he says because his right was violated his privacy right แล้วอะไรต่อนะ
แปลซ้ำแท้
and he want to collaborate with iLaw when iLaw reached out to him and this is a very important issue so he decided to file the lawsuit
ครับก็คือผมมองว่าเรื่องสิทธิส่วนบุคคลเป็นเรื่องที่สำคัญแล้วก็เมื่อโดนละเมิดเนี่ยเราก็อยากจะตอบโต้ทุกวิถีทางนะครับก็เลยใช้ช่องทางทางกฎหมายในประเทศไทยในการยื่นฟ้องครับ
Okay, human rights is very important, and he see that this is an opportunity to actually like file a lawsuit, and that's why he did it.
ต่อใช่ไหม
ต่อเลย
ครับก็เราก็อยากจะฟ้องเพื่อคือไม่ได้คาดหวังกับเขาเรียกว่าอะไรเงินที่จะได้มาจากเรื่องนี้เนาะแต่อยากคาดหวังกับความยุติธรรมที่มันจะเกิดขึ้นอย่างน้อยมันจะสร้างบรรทัดฐานใหม่ในสังคมไทยว่าหรือสังคมโลกเนาะเป็นตัวอย่างว่าไม่ควรเกิดขึ้นกับใคร
He didn't expect he doesn't really care about the money but he want this lawsuit to act as like a standard for the ongoing cases that happen outside of Thailand as well
ก็การที่ศาลรับฟ้องจนเรื่องมาถึงขนาดนี้สำหรับผมรู้สึกว่าเกินความคาดหวังแล้วครับ
Okay, when the court accepted the cases and it has come this far, he said that it's beyond his expectation already.
ครับเราเป็นแค่คนธรรมดาคนหนึ่งที่สู้กับบริษัทขนาดใหญ่เป็นของรัฐกับรัฐที่ทำสัญญาร่วมกันแล้วเราไปสู้กับเขาเนี่ยก็แค่นี้ก็ยากแล้วครับ
He said that he's just a normal citizen and NSO Group is a big company. So when it has come this far, he's already happy about it.
เพราะฉะนั้นผมคิดว่าเรื่องนี้มันคือการที่ทำให้สังคมโลกได้รับรู้ว่ามันมีกรณีแบบนี้นะครับผ่านกระบวนการศาลไทยครับ
Okay, so he said that he wanted the global community to learn from this case through the court proceeding in Thailand.
ครับแล้วก็ประเทศที่เป็นเผด็จการเนี่ยก็อันตรายครับสำหรับการที่ประชาชนจะอยู่อย่างมีสิทธิเสรีภาพ
He referred to Thailand as an authoritarian country and said that this is a dangerous situation in the authoritarian environment for people who actually want democracy in the country to campaign safely and peacefully without being harassed.
อย่างน้อยๆเราก็ได้เรียนรู้ว่าโลกมีการพัฒนาการสื่อสารและอีกขนาดเดียวกันก็มีการพัฒนาที่จะแฮ็กข้อมูลสื่อสารอยู่ทุกวี่ทุกวัน
Okay, so he said that this technology actually tell us that the world has developed in order for us to know that there's this kind of new technology that actually has been used against human rights activists and the pro-democracy activists.
แล้วก็มีประชาชนมีนักเคลื่อนไหวมีนักต่อสู้หลายคนที่ต้องได้รับผลกระทบจากการที่ทำธุรกิจสอดแนมแล้วก็ละเมิดสิทธิมนุษยชนครับ
And the findings in Thailand that the result of the investigation that came out in 2022 made us realize that the activists in Thailand have been infected with this kind of technology.
ครับวันนี้ก็อย่างน้อยก็อยากจะบอกให้โลกรู้เนาะให้คนได้รู้ว่าเราใช้โทรศัพท์ของเราอยู่ดีๆ ก็จะมีการเจาะเข้าโทรศัพท์ของเราได้ ไม่ว่าเราจะทำอะไรหรือไม่ทำอะไรณวันนี้มันถึงขั้นนั้นแล้วนะฮะ
Okay. He said that this is a new form of attack that your devices can actually be used to turn against you, and this is a new development for the activists in Thailand to learn that this is a new harm that is facing us at the moment.
ดูในหนังมันก็สนุกดีครับเวลาเห็นหนังที่มันมีการแฮ็กเกาะข้อมูลแต่โดนจริงๆมันไม่สนุกไม่ตลกด้วยก็อยากจะให้โลกได้รับรู้ครับ
So he said that if this scenario happened in the movie, it would be fun to watch, but in real life, this is actually not fun at all, especially if you are a victim.
ประมาณนี้ครับ
Okay. Next, I will move to Muwan. Would you please share with Chatmani? Sorry, I should refer you by your real name. So, we would like to hear more about the ruling in details yesterday.
Okay, so before we go into the ruling, I would like to start with how the proceeding went from the beginning until we had the ruling. So after we filed the case to the civil court and NSO responded with its defense, during the pre-trial conference, there are 3 dispute points that the court needs to discuss. First one is whether the defendant committed the act of tort, meaning that whether the NSO group used Pegasus spyware against Jatupat. The second point is what is the extent of the damages he suffered from the action of NSO group. And the third one is, has the case passed the statute of limitations? Meaning that you have to file a case within 1 year after you know that you've been violated and you know who should be responsible, or within 10 years after the act is committed. So after that, we moved to the cross-examinations. During this process, we tried our best to bring witnesses and documentary evidence. For the witnesses, we have 6 people in total, including Yingship and Sutawan, who served as the witness about the process on how they investigated the use of Pegasus spyware, and also the expert witnesses on international law applications to these situations, and the expert witness on how the computer and spyware works. So, and documentary evidence we submitted a lot, including multiple reports from Citizen Lab, for example, Gecko Spy, which actually focused on the use of Pegasus spyware during the pro-democracy movement in 2020 to 2021, and the findings from the National Human Rights Committees. But the key documents that started it all is the report from Citizen Lab that confirmed that Jatupat was infected by Pegasus spyware 3 times, at least 3 times during 2020 to 2021. And I want you to remember that documents because it's a key component in the ruling. So yesterday, the ruling has 2 folds. The first one is about the threat notifications from Apple. The court sees that there are some significant errors that the court did not believe that the plaintiff received the threat notifications from Apple. And the second one is that the report from Citizen Lab that confirmed that he was attacked by Pegasus spyware only shows that he was attacked 3 times. But the report does not show the forensic analysis, such as the abnormal IP address, binary code, password that can show that his device was affected or was attacked by Pegasus spyware. And because of that report, the plaintiff did not bring an expert who did the forensic analysis from Citizen Lab to testify about the method of forensic analysis and the abnormality of the content in his device. Therefore, we do not have an eyewitness, so the report itself was deemed as a hearsay evidence. And therefore, it is inadmissible under the Thai Civil Procedural Code. So that means that the court deemed that we have no evidence to prove that he was in fact attacked by Pegasus spyware. Therefore, the defendant did not commit the act of tort. So the court dismissed the case. So I think that's in a nutshell is the summary of the ruling yesterday.
I know that we had some problems. That's why the ruling got dismissed. Um, one of them is being about the information that iLaw submitted to the court. Could you please elaborate that a little bit?
Not iLaw submitted on behalf of Jatupat. But okay. First of all, I am also another victim of Pegasus spyware who found infections earlier than others, and we conduct research investigation on this matter, and we were here 2 years ago to tell the world that there are Pegasus spyware infections in the phones of at least 35 activists in this country. Third, I was also a plaintiff in the case first, but the court dismissed. Then we changed the case again and asked Jatupat to be the plaintiff himself. Later, I want to be a lawyer myself, but I didn't. I cannot hold all responsibility. So actually, iLaw have many roles in this case, including actually I was an expert witness in the case. So I might talk a lot. Please forgive me for that. We all are quite sad and disappointed for the court's verdict yesterday. Even though actually we have aware that this case, this mission to win is actually very difficult. We used to call it in Thai, we try to เอาไม้จิ้มฟันไปจิ้มยักษ์ literally it can be translated to we try to stab the giant with a toothpick, or we can say we poke the bear, and we know that we can make the bear feel maybe a little bit itchy, and they can kick us out of the way, or they can turn to kill us anytime. So we know that it's not going to be easy work to do. However, during the trials, we found many interesting issues. Thank you for the toothpick. We found NSO engagement, and we found testimony of NSO, which was quite surprisingly for us, that they came into Thai court and testify very much in details. That's what we got. We don't wish much to see that Thai court can grant us something, because we already know, we already aware that in many other cases that we work, when we try to sue something back, sue the government, sue the human rights violations, and ask for justice in this country, in this jurisdiction, it's not always easy. And in all cases, from my experience, we need to do 120% complete in order to convince the court that there is a human rights violation and they need to grant us something. So in many cases, other cases, when we can prove maybe like 90-100%, we always fail. But this case, we carry a very big disadvantage since the first, then when we start. We are fighting against a very big and very rich company who develop very sophisticated spyware, which we don't understand. We are lawyers. Pai is also a lawyer and activist. We don't know computer techniques. We don't understand what is spyware, how it works, how we can detect it, what can it done to our phones. So we are quite rely so much on what George Scott Elton and Citizen Lab can do for us. We did try to contact many computer experts in Thailand and security labs in Thailand to check the phones and to find evidences, and they can do. No one can do. So this is very difficult work, and they know everything. NSO who create this, they can sell this for hundreds of millions baht for just one purchase. They have a lot of human resource, they have a lot of knowledge. So if they came and they fight the case, we know that it is not easy to win. However, we have to accept that due to the load of paperwork, we submitted an incomplete document to the court. and the court pointed out yesterday. We also copied translation from the previous case, or we copied from somewhere, and we did not cautious enough before we submit to the court. We missed to translate 2 sentences, and that opened the room for the court to distrust our claim. We as iLaw, we have to apologize for our negligence, but I still believe that this is not the main factor at all. It's just a room that the court picked it up among many other factors. And the most crucial point that we should be discussed today is the burden of proof. The most crucial point that stands out from the verdict yesterday is the court insists too much that we as a victim, as an activist, as the plaintiff in the case, has a big burden of proof to prove everything that we are really infected, and there are some attacks from spyware to come to our phones and do this and do that and prove into all damages, which is almost impossible for us. From my point of view, I understand that the court may require, may want to see or want to hear more from the computer expert who really detect the spyware, because they don't understand. They are also lawyers. They are also common people who don't understand spyware, so they want to hear from George Scott Relton or anyone from Citizen Lab in details on how we detect the spyware. In this case, they don't hear that enough. So it is difficult for them under this political environment to give us something. But we thought we got enough. We know that we cannot get that 120% to win the case, but we got something. At least we have a document from Citizen Lab. This is the main document that Citizen Lab provide to us. We call it certificate that Jatupat is rarely infected. And this is the main document that we submit to the court, and the court thinks this contains not enough detail, and there is no many other things. And during the trial, we also have Ploy Suthawan, who actually testify a lot in detail. Suthawan is not just a Thai activist, but she also worked with Citizen Lab. Even though John doesn't come himself, but Suthawan was there and present a lot of methods that Citizen Lab used to detect spyware. I thought that was also enough for our burden of proof to say that we are infected. So can you explain more, please?
Actually, I think that I want John to address first about the reason that the Citizen Lab couldn't participate in the testimony. John, okay, the floor is yours. Can you
Very well. Can you hear me now?
Yeah.
Great. Well, hello, everyone, and thank you for allowing us to join this meeting. I want to begin by first acknowledging the plaintiff and target in this case, Jatupat, for his bravery in coming forward and participating in this process. I want to acknowledge his counsel, Chatpani, as well as the incredible work done by iLaw, Yingchip, and Suthawan. For us at Citizen Lab, it is remarkable to see civil society in countries around the world taking cases like this and seeking to achieve a degree of accountability, especially against a very strong wind blowing in the other direction. As the interventions by Suthawan and Yingchip have notably highlighted, there is a challenge around the world, which is there are many victims and individuals targeted with Pegasus, and a relatively small number of technically competent organizations in a position to participate as expert witnesses in their cases. We can think of hundreds, perhaps thousands of victims who will at some happen to them. This creates a really important challenge for the research ecosystem that does these investigations. There are several organizations, Citizen Lab, Amnesty International is another, Access Now, who are in a position to do this kind of research and work, but the capacity is spread extraordinarily thin. And it is even more challenging when it's not possible to participate in hearings remotely using a technology like Zoom. As Yingqi clearly pointed out, there was a challenge in identifying experts in Thailand, and indeed even more globally than that, who would be in a position to come and to testify during this time frame. And we at Citizen Lab regret very much our inability to testify in this case in person, but are deeply heartened by the incredible work done by this legal team, by DigitalReach, and of course the bravery of the plaintiff in participating in this case. I think this highlights the value for funders and others in seeking to support and build an ecosystem of technical capacity that's in a position to support cases like this around the world so that it doesn't all fall on a small number of researchers, but also it shows the importance of, as Yingqi has pointed out, educating the judiciary in the kinds of elements that happen in these spyware cases. There's of course a huge disempowerment for victims who are in a position of trying to seek accountability from secretive companies whose technology is used to monitor and control their devices, and judicial systems that are unfamiliar with this technology, and civil society groups that are also just beginning to build their capacity. At Citizen Lab, we're highly confident that the plaintiff in this case, Jatupat, was infected with Pegasus spyware at least 3 times across 2021. There could have been more. We are also confident that in time, cases like this and the efforts of organizations, including iLaw, the lawyers for the plaintiff in this case, will help us achieve a place where there's more possible. But I think there are many good lessons to learn about the gaps in capacity and the challenges that exist for this kind of work.
Okay, all right. Thank you so much, John, for your answer. Back to the Okay. Can we ask you one question, John? How do you feel when the court said that she doesn't believe in the result of the investigation? She doesn't believe that the infection happened for real. Can you hear me? Can you hear me?
I need to be unmuted. Yes. Can you hear me now?
Yes.
Okay. So as a researcher and somebody who's worked very closely with some of the people who you see in front of you today in person, this is obviously a disappointing conclusion by the judge in this case. What's interesting about Jatupat's case is, although it fits among a larger set of cases of infection with Pegasus in Thailand, his case is also one of the cases where we are not the only organization that confirmed infection. We shared aspects of this infection with the research team at Amnesty International, who validated the infection. The research that we do, the research that Amnesty does, has been validated in other courts before, in other jurisdictions. It's led to patches to billions of devices around the world, and is widely considered highly credible and has never been seriously challenged from a technical perspective. We wish that judges around the world were in a better position to recognize and appreciate the weight and strength of these claims and to understand the differentials in power and resources between plaintiffs and victims and spyware companies and perpetrators of this kind of abuse. Unfortunately, as we saw with the verdict yesterday, that may not have been the case here.
Thank you, John. I want to clarify a little bit. When Yingqi asked me to elaborate about my testimony, though, it's because the Citizen Lab couldn't come, and there was questions with a lot of questions from in the cross-examination. One of it was to actually challenges my technical ability. I don't have a computer degree, so I use all my work experience to actually answer them. And I believe that it's actually credible enough. One of it was actually, if you actually had a chance to read the Gecko Spy, which is a report that came out following the investigation in 2022. The technique that was used to actually check the file that was infected with Pegasus was is called the DNS cache probing. That was actually provided to the court. And this technique, DNS is, stand for the domain name system. So this technique is actually internationally accepted. It was published in a peer-review conference, the Passive and Active Measurement Conference in 2021. And also, when the finding was out in 2022, it was featured in the international media, like Reuters, Al Jazeera, The Guardian. So it's really strange that the court said that it's not actually credible enough. Also, as one step, of the investigation, when it's out, there's a peer review of the result. The result of the Citizen Lab was peer reviewed by Amnesty Tech using an independent tool. So it was like two-step verification of that as well. So we were quite surprised why the ruling said that the infection is not real. Yeah. You want to elaborate on something? I think that I would like to give the floor to you to list out about the point that you think that the ruling is actually is not fair. Yeah.
Yeah. I would not say that it's not fair, but I would say that it could be much better if they try. But can I have my slide back, please? ขอสไลด์กลับมาครับผมขอบคุณครับ Thank you. This is the certificate by Citizen Lab. Said Jatupat is infected by Pegasus spyware for 3 times with the dates of infections. And we also submit reports from Citizen Lab that Suthawan is also an author. But there is Thai law here, section 95 of Civil Procedure Code. It said that the court next the court should hear the witness on number 2 only who has directly witnesses heard or known of certain relevant facts that are to be offered as testimony, provide that provisions of this clause shall apply only when no express provision or law or court order prescribes otherwise, which means they need anyone from Citizen Lab who came and testify directly themselves, not Suthawan who involved, not Jatupat who acknowledge the existence of that document. But we also have section 95/1, which is an exception that maybe the court can listen, can admit this kind of evidence. So there are 2 conditions. The first, according to the condition, the nature, source, and circumstantial facts of such hearsay evidence, it is believable that the truth is provable. Second, there is a necessity due to the fact that the person could not come as witness. So we look at this section and we think maybe the certificate from Citizen Lab should be enough, because according to the nature of spyware infection, there is not many people who can come and testify by themselves, and in Thai court they cannot come online. They have to be in the court in person. So in the nature of spyware detection or spyware investigation, there are only a few people who can do that, and they cannot travel everywhere. So we expect that the court can also point this out and admit this kind of evidence as paper. There is another issue that I want to raise, that it is also not very easy for John or from anyone from Citizen Lab who are seen as enemy of the NSO to travel around and to come and face NSO or NSO representative or lawyers or someone in the court very often. The NSO might has capacity to hire a lot of lawyers or representatives, but they have not many people. If they appear in front of NSO people many times, maybe that's also not safe for them. When we have this section and we have certificate from Citizen Lab, and we also have our Thai computer expert who confirm that certificate, any documents from Citizen Lab, Toronto University, it's reliable enough, and there are many documents from United Nations reports and many other documents from other reliable medias, big medias, The Guardian, whatever, who also trust the investigation and the report from Citizen Lab. I thought as the nature of the spyware detection, it should be enough. But the court insists that it is not enough. I'm thinking of an example, like if a person was hit at the head and he has a wound, he's got injured, then he went to hospital, he sued someone who hit him, and he has a medical certificate. That should be enough. Not all doctors have to come to court to testify. Because at the nature of going to hospital, if you have medical certificate and maybe receipt, that is enough to prove that the man was hit and he's got injured and he has to pay for doctors. So I thought certificate from Citizen Lab would be enough. But maybe the court does not yet understand the nature of spyware, that it is not easy to detect, and it is not easy to bring a very few experts to courts every day, and the court doesn't understand how the spyware works or how we work to detect them, and then NSO object that we don't reveal our methods, so the court don't believe us. Yep. So this is again on the issue of burden of proof, that if the court requires this much for a victim, for a person who was violated, and the court requires that person to be very expert and have all experts ready with them to testify in all details all the time and everywhere in the world. This is too much for a victim to be able to do. So we sometimes wish that the court already understand, and the court we wish that the court can maybe have some flexibility on the principle of hearsay evidence and try to use the exception here to believe the certificate, which they don't. Yeah. Sure.
Okay, so I just want to point out that the standard of proof in a civil case is very different from the ones in a criminal case. In a criminal case, you have to prove beyond reasonable doubt. But for the civil case, you have to prove that it is most likely than not that the defendant actually used Pegasus spyware to affect the plaintiff. But in this case, we also have witnesses that actually testified about the process of having backups, information, how they send the information to Citizen Labs. We also have a college professors to certify how reliable the result from Citizen Lab actually is. So in this case, legally speaking, the evidence from Citizen Lab should be enough, because not only we have two conditions here. So the first one, by the virtues of the evidence, it should be reliable. In this case, we have witnesses to testify that it is reliable, and we also have witness to testify about how the process was done. And the second one is the reasonable ground for them to not come and testify, which we also have a very good reason for them to not come. So for example, for Citizen Lab to do the testing and everything is like a game of cat and mouse. So they cannot come and just openly expose how they do the testing, what is the method, because the developers of spyware is listening. So it's really impossible for them to come. So it's very alarming that the court will not use the exceptions in this case.
According to the nature of this kind of case, we are carrying a huge disadvantage against the spyware developer. So I wish to see the principle from the court that maybe the victims should have some burden of proof. We can prove that we have some documents certifying that we are infected. That should be enough. And if the spyware owner, they should also carry some burden of proof. In this case, we can actually prove that the NSO knows. They actually know who are the targeted, how the spyware was used by customers. They have something they call activity log. They have something they call kill switch that they can use anytime if there are some misuse of that spyware. And this document is actually in their reports that they submit to the court themselves. They insist many times in courts that they have a system to check how their spyware are used by their customers, and they have technology capability and also contractual capability to check that who are actually the targeted. So I wish to see the court saying something like the spyware owner who carries a big advantage also have some burden of proof. If this person is not infected, if this accusation is wrong or not completely true somehow, the spyware owner who carry all capacity should bear some burden of proof to say something like this. But in this case, they said again and again that they know. But they said nothing. They haven't said that the plaintiff is not infected. If they say so, okay, maybe they have some, they said something already. But they said again and again that they know they have system to check. But they didn't even say that Jatupat is not infected. So maybe they also fail on the burden of proof that they are innocent. I just would like to see the court to consider this part. Yep.
Thank you so much, Jingshi. I would like to clarify a little bit about the DNS cache probing, just to prevent a misunderstanding. I think that I slightly misspoke a second ago about the method. This was how Citizen Lab found Pegasus user in Thailand only, and I think that maybe John can add about this a little bit.
Thanks, Tawan. So I just want to use this opportunity to highlight two things. First, there's a lot of evidence that we have provided in our reporting about the presence of a Pegasus user in Thailand. Our reporting included describing historical evidence using DNS cache probing, which is a technique for identifying potentially infected devices that we used. And as Suchawan mentioned, this is a peer-reviewed technique. We also highlighted that we believed at the time of that report that we wrote that there was an active Pegasus user. What I also want to point out is the remarkable work done by Suchawan in her testimony, which we think did an excellent job at highlighting and clarifying for the court many aspects of our work, our research, and our research methodology. And we think that was a very helpful thing for the court, and we wish that the court had seen it as closer to what it was, which was a detailed and expert discussion of our work. I'd also like to follow on a point made by Jatupat and Yingxi, which is this. There is a tremendous disadvantage that victims of spyware experience, which is in a civil court, they're not just victimized by a normal company and a normal company's technology. We know, including from NSO submissions in this case and many other statements that they've made, that they have an ability to investigate cases, and they would be in a position to know whether this plaintiff was in fact targeted with Pegasus, and that would extend presumably to many other cases like this. And yet, of course, they won't say. The issue that is especially tricky here is that Pegasus spyware is designed to be hard to detect. And the many corporate practices of NSO and similar companies are designed to obscure and hide both the infections, but have the feature of obscuring and hiding wrongdoing committed with their technology. And we feel very strongly that if NSO and similar companies were in fact responsible corporations, they would do everything in their power to undo the powers that this secrecy has to hide abuse. And unfortunately, we have seen again and again the opposite. Obfuscation, misdirection, misrepresentation, and efforts really as much as possible to prevent victims from getting any justice or accountability. It's a very unfortunate situation.
Thank you, John. Next, we have some questions that I would like all the speakers to actually address though. What do we learn from this ruling? What do we learn from this case? I think that I would start from Yingxi. Would you like to go first?
ไม่เป็นไรพูดบ้าง
One, Pai.
ไทยก่อนก็
Pai.
เลยครับโอเคเลย
Anyone would like to go first? What do we learn?
ให้ผมพูดใช่ไหม
พูดเลย ถ้ามีอะไรพูดเลย
ครับในเรื่องนี้ครับอีกเรื่องหนึ่งที่ผมอยากจะพูดก็คือในฐานะที่เรียนกฎหมายนะครับคือหลักการไม่ว่าจะของธรรมาภิบาลของบริษัท NSO ก็ดีไม่ว่าจะหลักการคุ้มครองสิทธิ์หลักการทางกฎหมายในประเทศไทยก็ดีหลักการดีหมดครับเวลาเขียนในกฎหมายแต่ในทางปฏิบัติเนี่ยไม่เป็นอย่างที่เขียนไว้ไม่เป็นอย่างที่กฎหมายไม่เป็นอย่างที่ระเบียบกำหนดไว้แปล
Okay, this is to clarify a little bit. During the testimony, when Shmuel Sunray, the head of legal team of NSO, came to Thailand to testify, he said that the company has some kind of human rights principle, like policy, that the company has to follow. So he's referring to that, and he said that it's really good on paper, it's really good when you just say it, but practically, it's really questionable whether the company actually follow that policy.
ความน่าแปลกของคดีนี้คือมีบริษัทที่ผลิตไวรัสเพกาซัสแล้วก็มีประชาชนในประเทศไทยที่โดนเพกาซัสแต่ไม่สามารถหาคนใช้ได้ไม่รู้ว่าใครใช้
The strange point about this case is that the 35 individuals were infected. They were found to be infected by Pegasus spyware, but then we don't really know who's behind the tool, this technology, who actually used it to infect the activists with that.
บริษัท NSO ปกป้องลูกค้าคือรัฐบาลไทย
NSO really protected their clients during the testimony.
แล้วก็กฎหมายไทยก็ไปปกป้องก็ไปให้ความชอบธรรมกับเรื่องนี้หมายความว่าในสังคมไทยการที่จะมีนักเคลื่อนไหวมีใครที่ออกมาต่อสู้เรียกร้องเรื่องประชาธิปไตยก็สามารถโดนเพกาซัสได้สามารถโดนเจาะได้
The ruling tells us that Thai law somehow protect the perpetrator. And this is actually a very dangerous setting because this means that in the future, if Pegasus is used again against pro-democracy activists, human rights defender, that means it's going to be very hard to make them accountable for what happened.
ก็ผมอยากจะทำให้เห็นว่าขบวนการประชาธิปไตยในปี 63-64 เนี่ยที่โดนสกัดกั้นจากรัฐบาลโดนจับโดนสกัดทุกม็อบเนี่ยวันนี้ได้รู้แล้วว่าที่รัฐบาลรู้ทุกอย่างเกี่ยวกับขบวนการเคลื่อนไหวรู้ทุกอย่างเกี่ยวกับเครือข่ายการต่อสู้ต่างๆเนี่ยเข้ามาจากเพกาซัส
He referring to the pro-democracy movement that happened in 2020, 2021. So he said that it's very likely that the government of Prayut Chan-o-cha at that time know about the movement, the pro-democracy movement, from the infection of Pegasus spyware.
ผมคิดว่าเพกาซัสมันไม่ได้แค่ทำลายสิทธิเสรีภาพส่วนบุคคลแต่มันทำลายประชาธิปไตยในไทยด้วยครับ
So this means that Pegasus is not only used to violate the right to privacy of human rights defenders, but it's also attack Thailand democracy.
แล้วก็จงภูมิใจเถิดที่เกิดเป็นไทยครับกฎหมายไม่ปกป้องคุณหรอกครับปกป้องคนอื่นครับ
Okay, so he said that you should be proud to be born as a Thai person because the law doesn't really protect you as a citizen, but protect someone else who's in power.
โชว์อันนี้ป่ะโชว์ที่เขาส่งมาป่ะใช่ไหมอย่างใช่ไหม
เดี๋ยวแป๊บนึง
โอเคครับประมาณนี้ก่อนฮะ
Anyone else?
Yeah, so I would like to insist again that we accept the verdict from the civil court yesterday that we did not successfully complete the procedural requirements to convince the court to be very flexible on the evidence principle and to help us to protect privacy rights and to take some responsibility from the spyware developer company. However, it does not change the fact that we are all really infected. Even though the court doesn't believe that we really receive Apple notification or we really infected, we just here would like to show that it is real. Yeah, even though we fail according to the procedures, but it is here. Many of us in this room are also infected and are also having this threat notification from Apple. Pi has one, I got one, and even though the injuries from spyware is not obviously seen like blood, like when we were hit, but it is running somewhere in our phone, and it may be still running again and again every day. So can you
กำลังเปิดครับ
find it? โอเคขอบคุณครับอันนี้ this is mine นี่ของผมนะฮะอันนั้นของเขานะครับไม่เหมือนกันนะฮะถ่ายไม่ได้แน่เลยมันสว่าง
เห็นไหมครับ
It's too small. We didn't upload it on the presentation, PowerPoint
คือ
presentation.
เวลาไปศาลน่ะมันโชว์แบบนี้ไม่ได้ไงคือถ้ามันโชว์แบบนี้มันก็จบแล้วนะ When we are in court we cannot just turn on the phone and give it to the court like this. We need papers and maybe some papers are not complete enough in the court views. That's another difficult part. It has just been 3 years. I calculated. The first day we received here, you see the date? เห็นวันที่ไหมเห็นวันที่ไหมmine said 23rd of November 2021, but his said something, yeah, different dates. But it has just been 3 years until today since we got the first warning, and we try to get to know what it is, how it works, and is it real, and how can we fight back against the human rights violators. It is a very challenging work for all of us to study more on computer issues and most of the paper are in English. Even though today we don't have the good court ruling yet for this country and for the global fight, we can say that we will continue doing. We will continue checking more phones of people who are at risk, and we will do more investigation. Even though we have only very few resources, if we can find new infections within the statute of limitation according to the law, maybe we still have the next case. Yeah.
I think that I want to add something. I think that it's really important that so after the finding came out, the investigation came out, the Thai Human Rights Commission did an independent investigation on the situation as well, like independently. So they published a report of their own in April this year, right? Yeah, in April this year. So that report wasn't considered by the court at all. Yeah, it's like the report of the Thailand Human Rights Commission had no weight on the case at all. Yeah. Chanmani, do you have anything to add?
I think we fought a good fight, but the fight is far from finished. And I think, just on a positive note, I think we should be proud on how far we've come. Like, we did the whole cross-examinations, now we had the first ruling. I think the lesson learned for me is how to move past the obstacles. As we see, the court set the burden of proof to be really, really high and really impossible to achieve. And for me, that opened up discussions on how you should interpret the procedural law. How the law should evolve with times and situations, especially this case, considering the nature of this case, that it's not a level playing field. One side is a mega company, the developers of spyware. The other side is the victim. So to me, the main question is how we can move past this and bring up a better case next time. So I think that's the note for me taken from this case.
So John, if I'm not sure if we have another case in this country, can you come?
When in Yingchip's early statement, you made this Thai expression, which Stowan translated, and you translated to poking a giant with a toothpick. And I see the global spread of civil society efforts and cases from plaintiffs around the world to try to seek justice, both from spyware companies and countries that have used the spyware. I would say that if you put enough toothpicks together, you get a pretty big stick. And I think that this case and the efforts by the council here, the courageousness of the victim, the support of DigitalReach and others, has continued to move this process forward. It is going to be a long journey, and to use a metaphor from English speakers, all of it is uphill. But with each case like this, we learn more. This case, the testimony that NSO provided, told us more about what was going on, put more things on the record. I see this as a long journey, and I think at Citizen Lab, we regret not being able to testify in this case, and we very much look forward to supporting as much as we can cases in the future, and also working to address this broader challenge of expanding expertise and ability to testify in an expert capacity in cases like this one. I also just wanted to add my personal respect and thanks to the victim and plaintiff for leading this fight with your personal case, and to thank everyone present here at this event for supporting the case and working so hard. It's enormously gratifying to us to see cases like this, but also we're of course sad by the result, but this is not the end.
Thank you, John. I'm really disappointed, actually. I had a high hope during the witness hearing. I thought we were going to win. But then no. I thought
The
that
lawyer team, they never
Yeah.
thought so, but they never said so.
well, I thought that if we won this case though, it would set like a new benchmark for other ongoing cases as well, and I think that it would inspire like a victim outside of Thailand as well that's maybe considering whether like I'm going to file a case or not, or other pending cases. Yeah, I think that is going to be like a very positive sign for other cases that's ongoing. Yeah. So what do you think, John? What do you think like how this case, like when the ruling is like this, how can it have impact on other ongoing cases outside of Thailand right now?
Thank you. So there are cases around the world in many jurisdictions involving Pegasus and other spyware abuses. And no case was as far along, specifically as a case brought by a victim, talking about the forensic analysis of a victim's device, to NSO. But there are cases brought by tech firms, there are cases brought by spyware victims. All of them are moving us in the same direction, which I believe is more accountability. I think what this case shows is that a scrappy group of nonprofits and some talented lawyers in Thailand can both pave the way forward and give us a lot to learn about what the weaknesses are when you're trying to bring cases and what things need to get addressed, but also techniques that work. And I think that this case is going to serve as learning for plaintiffs, plaintiffs' counsel, and nonprofits and civil society around the world who are all working to address the problem of the human rights impacts and harms of the proliferation of mercenary spyware. I see this as a researcher, somebody who's worked on the issue of mercenary and commercial spyware for over a dozen years at this point. And if you had told me even 12 years ago that we would be this far, that there would be a case that had gotten this far, I wouldn't have believed you. And this shows both how far we've come, but also it's a reminder of the challenges that we collectively face as we do this important work.
Thank you, John. Next step, are we going to appeal?
Yeah, I think it's in a plan that we will discuss. I think we will appeal, but just want to clarify it on that we did not think that it would not win. It's just that we didn't want to jinx it. Like in the cross-examinations, the court may have like positive outlook, positive attitudes and everything, but at a judgment, it could turn out to be a different story. So we didn't want to jinx it, so we didn't want to get our hopes up and like got destroyed at the end. So that's why we really laying low on if we would win and stuff like that.
Okay.
ด่า NSO ได้ไหม
Die. the problem is if we appeal, we cannot submit more witness anymore. So it must be depend on the witness that already testify. Even though John or other experts can come, they cannot testify in the appeal court.
ครับถึงแม้ว่าแพ้ในคดีนะครับก็ไม่มีทางให้อภัยมันนะครับแล้วก็จะจดจำไว้แก้แค้นไว้นะครับบริษัท NSO โดยรัฐบาลอิสราเอลแล้วก็รัฐบาลเผด็จการประยุทธ์นี่ก็คือผมเคยสู้ทุกรูปแบบแหละครับประเทศไหนใครอยากจะให้ช่วยอะไรอยากได้ข้อมูลอะไรบอกได้ครับแล้วก็ในประเทศนี้ถ้าจะสู้อะไรได้เดี๋ยวจะสู้อีกต้องเจอกูแท้ครับ NSO อีกบัก
He said even though we lost in the court case, but we will never forgive them, both the NSO and the dictatorship government. Whatever we can do to fight in any countries or anywhere, if we know how to fight, we will do.
ครับจบครับ
Okay. For Thailand, we are going to continue working on this issue. We still want to continue with the investigation for human rights defenders and activists in Thailand. Yeah, as part of our work in Southeast Asia. Yeah, and that's the next step. Yeah, I think. Okay, John, you have anything to add before we move to Q&A? John.
Well, I think I would just like to thank again the plaintiffs' lawyers, iLaw and you at the DigitalReach for your incredible work here. I can say that the challenge of spyware work is that progress is all uphill and it's not always forward. But in the long run, I have confidence that it is efforts like this, courage like this, and work like this that will get us to a better place. So I thank you all.
Thank you so much, John. Okay, we're going to have Q&A now. So if you'd like to ask any questions, so please line up.
Please,
Okay.
you can, yeah.
Yeah.
You can also speak in Thai.
Speak English.
Okay.
Okay. Isra Chai, now I was urban researcher, but I former Padichon journalist who report about this case in the first review of 40 victims in Pegasus spyware. I asked, especially John, you mentioned about tech firm, and I got to the point that in March this year, Meta just won the case about the NSO group and US court orders NSO to hand over the source code of Pegasus spyware and other products to Meta, because in case about tied to attempt hackings, 1,400 individuals through WhatsApp. And can you give some what element that's in the case in Meta won, but in case of Jatupat it's not?
Thank you for that question. I'm not a lawyer, so it's hard for me to say in different jurisdictions what may have contributed to different rulings or processes. I will note that the WhatsApp v. NSO case is continuing as of right now. And in fact, very recently, some documents submitted in that case were unsealed by the court and give us a much bigger perspective of some of the things that have been happening in that case. The most recent thing that I think we all were very surprised to learn when these filings were unsealed. So WhatsApp had discovered that NSO spyware was used to target over 1,400 WhatsApp users during a brief several-week period back in 2019. They patched the vulnerability, they sued NSO Group, and they notified the victims, and we at Citizen Lab participated in helping notify civil society victims. What we learned recently in these filings, the case is ongoing, is that NSO apparently had actually developed yet another exploit to target people across WhatsApp, and appears to have been doing that even after the WhatsApp v. NSO case was filed, which I found personally shocking. And I think it also points to a company that does not see itself as likely to face consequences. And so I think every effort to try to ensure that this company and others like NSO do face consequences, do have to fear plaintiffs, I think are really critical and important. Ultimately, the WhatsApp case is very different from this case because the WhatsApp case is about the hacking of WhatsApp's systems to infect devices rather than a single plaintiff victim or a group of plaintiffs bringing those cases. But I would note that other cases like the one in Thailand are ongoing in multiple other jurisdictions. So thank you for your question.
I think Muwan can add some answer to this as well, right?
I think also another thing that made the difference between the US case, the WhatsApp case, and also our case is the different procedural law. In the US, you have what you call a discovery procedure, but we do not have it here. So even though we can ask the court to issue a summon to NSO to give us some code or something like that, the court did not have the authority to compel them to send the code. They can always deny, claiming national security, claiming other reasons, or contractuals, confidentiality, and something like that. So I think that's another major difference than the outcome in the Thai court and also in the US court.
And anyone else? Okay, you. For online participant, if you have any question, you can actually submit it as well on Zoom, and our team will bring the question here.
Hi, good evening. My name is Imtiaz Muqbil. I'm the executive editor of Travel Impact Newswire. I actually cover the travel and tourism industry, but I have a very deep interest in human rights and democracy issues. I had a couple of questions. One is, right from the beginning, you mentioned that you had received a note from Apple informing you about this. I was just wondering, what is the legal responsibility of Apple to give you additional information about what they knew and when they knew it?
Oh.
Was that brought up in the, was Apple asked to come and testify about where they got this information from and how they could prove that your phones were infected?
They should have some responsibility to explain what they have detected and what did they notify us. But
Yeah.
we try. We don't know how to contact them. We try. I myself try to contact Apple sometimes, and we haven't get any more explanation besides the notification that we got.
So they did not respond to
Yeah.
your inquiries?
Yeah. Actually, in the end of the email, it said don't reply. But I tried to contact other channels of the Apple, and I haven't got any explanation yet.
So they informed you that your phones were infected, but then they told you not to reply and they didn't respond to your... Okay. So that's a curious issue there. So the second question that comes up then is on the issue of the... You mentioned a minute ago, you said NSO did everything possible to protect their clients. Is that correct? Yeah. And then your press release also says here, there is no law in Thailand that gives both the government and private sector the power to access information on the phone like this. Right? So if NSO is protecting the clients and there is no law that gives both the government and the private sector, this means that NSO is saying, we just sold it to these people and they will protect who these people are who bought it. Is that right? So we don't know who bought the NSO software in Thailand. We don't know who that is. Is that correct?
Yeah, we don't know who exactly is the one that buy the Pegasus spyware. We don't know if it's the government itself or if it's the other authorities under the government that actually the parties to the contract. The thing is that we try to file a summons to every authorities in Thailand that we can think of that may have been the one that bought the Pegasus spyware. The court rejected our request to have the summons for those kind of documents. They said that we are not clear enough and they did not believe that those authorities have such documents in their possessions.
Okay. So as you look forward on, will you be looking to fix this problem, that there is no law in Thailand that gives, does Thailand need such a law as you go forward on the legal issues? To explore this?
Yes.
I mean, what did the Human Rights report, you said the Human Rights Commission issued a report. Did the Human Rights Commission report make any mention of this? The fact that there is no law in Thailand that gives government and private sector the power to access information?
Yes, there is no laws that provide full power for the authorities to access to our phone anytime, anywhere without court warrants. But there are some laws provide the power to some officers to seek court warrants to access to our phone. But we need a law. We need a law to regulate that how much they can do, in what conditions, and there should be some punishment if they overuse their power.
Okay, and final question. Thailand has now just been given membership of the UN Human Rights Commission for 2025-27. Are you planning to take it up through that area? Because now Thailand is going to be on the commission, and there are international regulations, international laws on this issue, which have been, I think, signed by Thailand via the Foreign Ministry. And if it's going to be on the membership of this Human Rights Commission, is there an opening there that you can look into?
Yes.
And maybe somewhere along the way, I'd like to get John's comments on some of the questions I've raised as well, please, before I sign off. So please, thank you.
Thank you. Thank you very much.
Thank you.
Will you? So sorry, just on that human rights issue, could you answer that? Will you be planning to take it up?
I think that we can work with other organizations on this matter as well. But given the record, I just don't really know how impactful it's going to be. That's the thing, but we can actually work on that. I think that one of your questions that talking about the traces of Thai government agency under the Thai government on the use of kind of cyber surveillance technology. I think that John can actually elaborate on this as well, based on your research that you found the trace that some Thai government agency might have been using some kind of, cyber surveillance technology, to abuse human rights in Thailand.
So I think what you're referring to is during initial internet scanning for a report that we wrote in 2016, we identified a cluster of Pegasus servers that were associated with some domain registrations that suggested a potential link to the Narcotics Suppression Bureau in Thailand. So this is fairly old activity. We're really looking back about a decade. And then in 2018, we published a report titled Hide and Seek, using DNS cache probing, where we identified a single Pegasus operator active in Thailand with victims across Thai networks. And then more recently, obviously, we've also found, as we wrote in the Gecko Spy report, we found other evidence of potential Thai use of Pegasus spyware.
National intelligence.
Okay. On August 1st this year, what do you call it? The National Committee on National Security. It's a really long name. National Security and what? National Security.
Sorry.
It's a really long name.
กิจการชายแดน border affairs.
Yeah, National Security and Border Affairs that, Rangsiman Rome is the chair right now. So we actually submit a petition to the committee as well, and then they invited the Narcotics Suppression Bureau, the National Intelligence Agency, and what's the other thing? What's the other one? There's three of them. Narcotics Suppression Bureau, the National Intelligence Agency, and
ISOC.
and the
Ministry of
Internal Operations Command. Yeah, Internal Security Operations Command. Yeah. So this is actually linked to what John just said in referring to his report. So all these three agencies will actually question whether they know Pegasus or not, and whether they have used it or purchased it in any of their work. And the Narcotics Suppression Bureau, the representative of it, said that they used to purchase it, but then they stopped purchasing it since 2020 because they ran out of budget. Yeah. So it's matched with the report of the Citizen Lab as well. Yeah. But then it really cannot be confirmed whether they have used it to abuse the right of human rights activists during the height of pro-democracy protests in 2020 or 2021. Yeah.
Jatupat just asked me to speak on behalf of him in English to emphasize again that there are some legitimate goals to use some technology to spy on people. For example, terrorists, pedophile, or selling drugs, narcotics, something. But we have to emphasize that for political activities, for political activists, it should be strictly banned that the government should not use any technologies to spy on people for their political opinion or political protest activities, whatever. เข้าใจ
ครับ
ขอบคุณครับ
And anything else? Is there any online question? No?
โอเค
please
ถามภาษาไทยก็ได้นะครับ
ทำภาษาอังกฤษก็ได้ครับ คุณรู้เปล่าว่าคนที่เขาเซียนมากด้วยภาษาอังกฤษเนี่ยผม
Okay. Hello, my name is Cham and I'm also an activist. When I listen to what you say about the burden of proof, I come to think of the same thing about the forced disappearance. And the burden of proof is on the victim family too. And as such, we have a new law to combat this. So if you think that we should have another law to combat this as well to help with the burden of proof of the victims.
Good idea Thank you คุณแชมป์เขาบอกว่า
ในคดีพวกเนี้ย
เมื่อภาระการพิสูจน์มันตกอยู่กับโจทย์มากไปในคดี spyware งั้นเรามีกฎหมายที่เปลี่ยนแปลงภาระการพิสูจน์แบบนี้ดีไหมจากที่คิดไม่ได้คิดได้เลยส่วนจะเอาไปทำอะไรเดี๋ยวขอคิดดูก่อน ขอบคุณครับ
ครับโอเคนะครับ
พอแล้วนะครับ โอเค
ครับ
Well thank you for coming today
ขอพูดอีกหน่อยหนึ่งได้ไหม
ได้more
Okay thank you everyone may I speak a little bit in Thai to my friends นะก็งานนี้เสียพลังไปเยอะนะครับเสียลงแรงกันไปเยอะแต่ว่าเราได้พัฒนาศักยภาพของพวกเรามากในการมาเรียนรู้เรื่องยากๆแบบนี้ไม่ได้ผลทางคำพิพากษากลับมาเลยนะต้องยอมรับว่าไม่ได้ผลคำพิพากษาที่เป็นประโยชน์เลยแต่ไม่เป็นไรเนาะโชคร้ายหน่อยนึงก็คือมีเพื่อนเป็นพลอยแล้วก็งานนี้ก็อยู่ในโปรเจกต์ปีหน้านะครับก็ยังมีอะไรต้องทำกันอีกเยอะก็หวังว่าจะได้ร่วมทางกันในงานยากๆนี้ต่อไปเรายอมรับว่าแมตช์นี้เสียกำลังใจอยู่บ้างแต่ไม่เคยท้อครับผมขอบคุณครับ
Thank you everyone
Thank you so he
เดี๋ยว
said
จะฟังไม่รู้เรื่องนะป้าป้อมนะฟังรู้เรื่องกันนะ
so he said that this is actually like what you call a new environment the new environment for human rights violation in Thailand this technology was discovered so he said that he put a lot of energy he threw a lot of energy into it and we threw a lot of energy into it and there's really nothing back. I disagree though. There's really
I can speak again. I can speak again. You don't have to translate me. But luckily because we have Sutawan as our colleague, so we have already set up our project in next year that we're gonna keep on fighting on this issue on Pegasus, on spyware, on privacy, digital rights. There are still much more things that we have to do together, and I hope everyone will be alongside with us on our fights. We have to accept that we feel sad, but we will never give up. I have learned it from Jatupat years ago. Yeah.
ตามนั้นละ
Okay, one of the thing is I think that it's really necessary for Thailand to actually think about a law to actually prevent the abuse of cyber surveillance technology in the country, and I think that it can be the next step for us to move forward as well. Okay, thank you for coming tonight. It's actually a lot of fun despite the disappointment. Thank you so much. We hope you had a good evening. Thank you.
Thank you,
See you
John.
next time. Thank you, John.
See you
Thank
next
so
case.
much.
I still have my case pending in the court. Sorry, I forgot.